Corporate governance. Corporate governance refers to the way in which a company is managed and controlled. We saw in earlier videos that one of the distinguishing features of a large company is the division or separation of ownership and control. Decision-making responsibility is divided between the board of directors, who manage the company, and the shareholders in general meeting, who own the company. In smaller business organizations, including sole traders and partnerships, the same people own and manage the business. But with larger companies, one group of people own the business and another group of people manage the business. Corporate governance is about the relationship between those two groups of people. A case that illustrates the relationship between the directors and the shareholders is Automatic Self-Cleansing Filter Syndicate Company Limited and Cunningham from 1906. A shareholder in Automatic Self-Cleansing Filter Syndicate proposed that the company sell certain of its assets. At a general meeting, the shareholders resolved to direct the directors to sell these assets. The directors refused to comply with the direction because they believed that the sale would not be in the best interests of the company. The shareholders commenced legal proceedings, insisting that since they were the owners of the company, the directors had to do as they were told. The court decided that the directors were entitled to refuse to obey the shareholders. The company constitution gave the power to make such decisions to the directors, not the shareholders. This is an illustration of a fundamental point about companies. The directors are not under the control of and subject to the direction of the shareholders. Instead, each group, the shareholders and the directors, play an important role within the management of the company. The directors have the power to generally manage the business of the company, and the shareholders are only entitled to vote on limited matters. We'll now consider each of the two groups separately. So the directors. Proprietary companies must have at least one director, and public companies must have at least 3 directors. A director of a company must be an individual and not a company, be at least 18 years old, and not be disqualified. A person may be disqualified from being a director if, for example, they are bankrupt or they have been convicted of certain fraud-related criminal offences. As you can see, the requirements that need to be satisfied in order for a person to be a director are fairly generous. One does not need a university qualification, for example. We usually distinguish between executive directors and non-executive directors. An executive director is involved in the full-time management of the company and is an employee of the company. The CEO or Chief Executive Officer and the CFO or Chief Financial Officer are executive directors. These are the people who work full-time for the company in managing the company. Non-executive directors, however, are not employees of the company. These people usually have full-time positions elsewhere and engage in management of the company when they participate at board meetings, which may only be held monthly or every few months. When the board acts collectively, its decisions are the decisions of the company. So it is rare for an individual director to have the authority to act on behalf of the company. A director will have authority to act on behalf of the company if they have express actual authority. In other words, the other directors have expressly authorized one director to do something on behalf of the company. They may have implied actual authority, although this is relatively rare for individual directors. It's usually only the CEO who has implied authority to act alone on behalf of the company. And of course, a director may have apparent authority to act on behalf of the company if the requirements of apparent authority are satisfied. Directors owe a range of statutory duties to the company. A director owes a duty of care. In other words, they must exercise their responsibilities as a director in the same manner that a reasonable director would do so. A director owes a duty to prevent insolvent trading. If a director permits the company to continue to trade while insolvent, the consequences can be quite serious for that director, including the director becoming personally liable for debts that are incurred by the company while it is insolvent. A director owes a duty to act in good faith, which means they have to act honestly and in the best interests of the company. A director owes a duty to act for a proper purpose, so any powers that they do exercise have to be exercised for the right reasons. And a director owes a duty to disclose to their fellow directors, and in many cases to the shareholders, any conflicts of interest that they might have. The consequences of breaching any of these statutory duties are quite serious. A director found to have breached one or more of their statutory duties may be disqualified from being a director, fined up to $200,000 for each breach of duty, ordered to compensate the company for any loss that the company has incurred as a result of the breach, and or ordered to pay to the company any profits that the director has made as a result of the breach. If the breach was deliberate and fraudulent, they may be subjected to criminal penalties as well, including, in some circumstances, a jail term. The shareholders. Each shareholder is a part owner of the company. This means that they own a bundle of rights. They have voting rights, they have distribution rights, and they have the right to receive information. So voting rights refers to the right of most shareholders to participate in shareholder meetings and to vote on certain resolutions. Distribution rights means the right to receive a distribution of the profits of the company in the form of dividends. And the right to receive information is the right to stay informed about the activities of the company. Just as directors act collectively as a board of directors, shareholders exercise their power collectively in the form of general meetings. Public companies are required to hold at least one general meeting every year, known as the annual general meeting. Companies can, of course, hold additional meetings, and these are usually known as extraordinary general meetings. As we saw earlier, shareholders have limited decision-making power. It's usually the directors who make the decisions when it comes to management of the company. However, the Corporations Act and the Constitution of the company will usually grant shareholders the authority or power to make decisions in relation to the structure or constitution of the company, decisions relating to the composition of the board of directors, including who should be appointed as a director and whether directors should be removed, and decisions to veto or override certain transactions, including related party transactions by public companies. A shareholder who is dissatisfied with the way the company is being managed may be entitled to a number of different remedies. So they may be entitled to commence a legal action against the company if they can establish oppressive conduct. For example, if the directors or a majority shareholder is preventing them from participating in decision-making processes. They can seek an injunction to stop a director, shareholder, or other person from breaching the Corporations Act. And in a limited range of circumstances, they may be entitled to bring a legal action against the directors for breaching their statutory duties on behalf of the company. This is known as a statutory derivative action, and the court will usually only permit this where the shareholder is able to establish that the directors may be getting away with breaching their statutory duties and that the company is unlikely to bring a legal action against the directors itself.